Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States in this honorable court.
Hello, Mr. Mongaras and Mr. Goldman. Welcome to the Fifth Circuit. I'm Judge Dennis, together with Judge Engelhardt and Judge Hicks. Will be your panel today. We have three cases to be argued. You're first up in the United States of America versus Danny Jewell, number 2010814. So with that, Mr. Mongaras, I think we'll hear from you first.
Sir, thank you, Your Honor. May it please the court, counsel. My name is Joey Mongaras, and I represent Danny Jewell. Put simply, the district court in this case applied a two-level enhancement on the basis of unsubstantiated hearsay, amounting to nothing more than a conclusory statement in the PSR that didn't have any indicia of reliability. Here, what we have is Mr. Jewell effectively received methamphetamine from a co-defendant named Wise, who then received methamphetamine from a co-defendant named Maxwell, who then received methamphetamine from another unknown co-defendant, or not even co-defendant, unknown person, who then received methamphetamine from another unknown person that was supposedly in Mexico. When these transactions occurred between Mr. Jewell, Mr. Wise, and Mr. Jewell never met Ms. Maxwell, when these transactions occurred, according to the PSR, are completely unknown. So we don't know when these transactions occurred whatsoever. So what we have now from the government at sentencing is they provided some rebuttal to my claim that it was unsubstantiated hearsay and unreliable hearsay. They provide a statement that is highly redacted, and we don't know who this person is, that says at some point within the last 3 months or 6 months, they gave methamphetamine to Miss Maxwell, and that their source, they don't know anything about their source other than that they were in Mexico.
Mr. Mongaras, let me interrupt you and ask you a question. Page 35 of your brief, you argue that there was no jointly undertaken criminal activity between Maxwell, who acquired the so-called imported drug, and the appellant, who acquired the drug from both Maxwell and another one of Maxwell's distributors, Wise. In this particular instance, if they all pled guilty to the charged conspiracy, how do you say that there is no jointly undertaken criminal activity with your client?
Yes, Your Honor. My understanding, and that is based upon 1B13, is there has to be some joint agreement between at least Mr. Jewell and Ms. Maxwell, which here there wasn't. There was a joint agreement between Mr. Wise and Mr. Jewell to receive methamphetamine. He's never met Maxwell or knew who Maxwell was.
And I understand that, but the question I have is the acquisition of the meth from Maxwell as part of the conspiracy. How do you simply manage in this master conspiracy to disengage your client from that? I need some help on that because I'm not following your accident. And I understand Maxwell, of course, had other sources of supply, and I'm struggling with that statement in a master conspiracy with everyone having pled guilty.
Yes, sir. And based upon my understanding of at least getting to not the conspiracy, we understand I understand in the conspiracy, there are multiple co-defendants, but here in determining at least irrelevant conduct of Mr. Jewell, my understanding of 1B13 is there has to be some jointly undertaken criminal activity. And it just says within the scope of that activity and furtherance of that criminal activity and reasonably foreseeable of that activity. It doesn't necessarily say, my understanding of that and in the notes of that jointly under criminal activity would be that he would have to have some agreement with Maxwell, not just Mr. Wise. And and I understand where the court's coming from. However, I think it would be, we'd be, if it was with the court's understanding, we would have where if you just have any sort of agreement with one person, your relevant conduct would be with what everyone else gave that one person. And I don't think that's what.
Let me ask the maybe the inverse of what Judge Hicks is asking. Are you arguing that insofar as the other actors are concerned, that their conspiracies were with other people, not including your client? Wouldn't that have to be the case?
I think that would be. I think that would be correct. I mean, I think we're getting into whether or not what can be proved at trial and what can be proved and what is needed as far as relevant conduct.
Well, but is it the standard plausible in light of the record as a whole when we talk about as a sentencing factor?
I think it would be if you had some sort of jointly criminally undertaken activity between, let's say Mr. Jewell even knew who Maxwell was or met Maxwell, then I think that would be taken in as relevant conduct. Absolutely. But here, you just have you have transactions between Jewell and Wise. The rest is so tenuous as regards to, and even if it was from, let's say you want to put that jointly undertaken activity with Miss Maxwell. Let's say that that is the case here. We still have two more people where meth is coming from. Maxwell's not the source. She has another source, and that source has another source. So at some point, I don't think the guidelines, especially under 1B13, call for 5 people later down the chain. I think at some point it has to be cut off with where you want jointly criminal activity.
What's your best case for what you just said, your proposition that I understand your argument. Is there a case that we can look at that would support that?
With regards to 1B13, I do not have a case. I can supplement later if the court deems that necessary. My focus on this, and it was only to get to the 1B13 analysis if, I guess, 2 things. One, we don't believe here there was enough evidence or reliability, and only based on conclusionary statements, if you want to narrow that down into uncorroborated hearsay, that this meth was not from Mexico, or the meth that Jewell received at an unknown time at an unknown place was not from Mexico. There was not enough indicia of reliability in the PSR to show it was from Mexico. Now, in the court's statement saying his tentative rulings were, Sturfis says if the drugs are from Mexico, there's really no other analysis. That wasn't my argument. My initial argument here was there is no indicia of reliability from the PSR whatsoever, or by the government to show any reliability. This court has said and granted in for warrants what has given kind of a definition of what conclusionary statements are. And it's just, has cause to believe or reliable information from a credible person that says this. In warrants, that's not enough. That's bare bones. Here, it shouldn't be enough either for the government or the PSR just to say, we have an unknown source at an unknown time that we deem as credible, but no reason. And here, there's no testimony from an agent to say why that's the case. We just have the drugs must be from Mexico. And so what I guess my first point was, if the courts are going to say that the drugs are from Mexico and this is going to be a strict liability that all meth is from Mexico, then at least have some. That's where I got to the 1B13 analysis. At least have some analysis because the guidelines don't have notes with regards to this enhancement, like in a weapon enhancement or even in the premises enhancement where they have guidance. Here, there is no guidance on the guidelines, and that's why I'd asked, other than 1B13, that analysis be used. So that's why that's how I got to that analysis. But I just want to make clear here that the drugs were not from Mexico, and if the court looks closely at the PSR and closely at when Mr. Jewell was actually arrested, he was arrested in September of 2019 and was kept in custody that entire time. The interview that the government provided was in November of 2019. The source from Mexico would have to be back 3 months, possibly 6 months from that. And again, we just don't know any of this information because it was unknown time, unknown place. And the government never is going to be able to say, there's no ledgers, there's nothing to corroborate the fact that these drugs could have been from Mexico. And distinguishing other cases that the government put in their brief, this isn't, well, we're just guessing that they couldn't be from Mexico. Ms. Maxwell has another source here. And so that other source is a domestic source. It was never proven through the PSR or by the government that domestic source, that those drugs were from Mexico. So there isn't a possibility that it's not a guess by Mr. Jewell's part or my part. It's actually in the record showing that Ms. Maxwell had other sources that weren't deemed or proven or shown to be from Mexico. As far as the premises enhancement, I understand that argument is, while Mr. Jewell did understands that here another co-defendant, Mr. Pipkin, stated that he bought methamphetamine from Jewell at his residence. However, that residence was not the residence on Henderson, and there's no factors or facts to believe where that actually occurred. Again, this was more of an objection on asking the court just to have someone, or the PSR as well, to have some analysis as to whether or not it can be proven by an indicia of reliability. And it kind of goes to the totality of the circumstances here. Here, one drug transaction, what took place on Henderson Street. Mr. Pipkin had said he went to 2nd Street, and so we know nothing about 2nd Street. All we know is facts about Henderson Street, and what we know about Henderson Street is that that's not Mr. Jewell's residence, that's his mother's residence. So that's what we know. And so according to the factors that the guidelines lay out, I didn't believe that was enough to give him based upon just what the PSR said. Lastly, we believe that Mr. Jewell's sentence was substantively and procedurally unreasonable. I understand, and as trial counsel, that I did not object after the sentence, that it was procedurally unreasonable. However, I did put on notice that the court came out with tentative rulings, and then while discussing 3553A factors, the court later on interjected, and from the context of what I believe him to say is that he doesn't make the guidelines, and I understand that, but instead the court continued and said he took an oath to uphold the law and follow the guidelines that Congress has given.
So if we were to accept your arguments on both of the 2-level enhancements and assume that the guidelines were reformed to subtract those 4 additional points, how do you get around the 3553A imposition of sentence and it's reasonable under the 3553A factors? So we correct your guideline calculations, but we still use 3553A as the judge said he was using. Now what?
Correct. Well, so Your Honor, and I understand that I don't believe the court used 3553A, and that's why what we put in our brief, and whether or not it's clear error or plain error, I don't believe, and in order to determine whether it's procedurally unreasonable, I don't believe the court took into consideration those factors. We don't know for sure because the court never gave an explanation, period. Even after I told the judge he's not bound by the guidelines, I did put the court on notice, 1, by filing a memorandum for departure, and 2, letting the court know after he explained that these are, he follows the guidelines. I did let the court know then that they're merely advisory. So I don't believe the court took into account any of the 3553A factors. And if he did take into account 1, it would be criminal history. He did not take into account the fact that Mr. Jewell would be ineffective getting this sentence along with the parole revocation, which was another 13 years. He did not take into account any of the 3553A factors I laid out in court of Mr. Jewell's poor health, substance abuse, being abused as a child, never receiving counseling, none of those factors were discussed. Those factors were discussed to the court, and none were taken into consideration. And I guess that's with regards to the 5G argument in my brief, and in essence for his time served in my brief, and even the objections taken as a whole, and the totality and context of the entire sentencing as a whole, it's clear the judge, he made no analysis with the objections, and he made no analysis with the 3553A arguments whatsoever. I understand he doesn't have to say his complete sentence, but he has to at least give some sort of explanation of the sentence.
In this instance, then, it's your position that the court is under an obligation to explicitly address each 3553A factor, as opposed to simply stating a 275-month sentence flowed from the court's, quote, consideration of all of the factors set forth in, end quote, Title 18 U.S. Code Section 3553A?
I'd ask that the court at least take into account some or all of the factors. The court said he took into account the factors, but then never gave an explanation. So I don't know what the court came up with, that how or why the court came up with that sentence.
Is it your statement that there's a case holding that he must elaborate and state which factors predominate? Or is the simply a court's conclusion based on all of the information available to it that it's a 3553A decision for a 275-month sentence? Is that a change in the law to require a judge to do that?
No, sir. And I understand my time's up. I recognize the fact that the courts can say very little, but I would at least ask for some explanation or some analysis as to why a sentence was given, especially after the court had made comments with regards to they don't make the guidelines, but they follow the guidelines as written. And so that's what we're asking here.
Thank you, counsel.
Mr. Goldman, we'll hear from you.
Good afternoon, Your Honors. Ross Goldman for the United States. I'll start by addressing the premises and the importation enhancements. And I do want to make one top line point here, which is I think where the court ended off with its questioning, even if this court were to conclude for some reason that either or both of these enhancements were improperly applied, the district court statement at page 171 of the record on appeal makes abundantly clear that any error did not affect the imposition of the 275-month sentence. Under cases like this court's decision in Metal Guadalupe and Shepard, that statement is itself sufficient to basically moot any merits objection to these guidelines enhancements. And indeed, in Metal Guadalupe, this court didn't even resolve the merits of the guidelines enhancements because it was so clear that any error was harmless. And this kind of statement that appears on page 171 is precisely the kind of statement that this court in Shepard encouraged district courts to make in order to obviate these kinds of guidelines appeal claims where it is so clear that the enhancement did not have an effect on the sentence that was imposed. I think that's the top line point I want to make. I think that's probably the easiest and cleanest way for this court to deal with the enhancements. Turning to the merits of those enhancements, so just a couple of points. The first point is, with respect to the premises enhancement, the PSR says at pages 180 and 181 that these drugs transactions, roughly 30 of them, took place at Mr. Jewell's residence. Now, my friend on the other side has said that actually the Henderson address was his mother's home and that Mr. Jewell didn't live there. I would point the court to page 195 of the record on appeal, which is the PSR, and the PSR there states that the defendant reported the following residential history, and says from 2004 to 2019, when he was not incarcerated, he resided at his mother and grandmother's residence located at, and then it lists the Henderson address. I think there was ample evidentiary basis for the district court to find by a preponderance of the evidence that the premises enhancement applied. That factual finding is reviewed for clear error only, and this court would have to find both no plausible basis in the record to support that finding and a clear and firm conviction that an error was made. The district courts are entitled to rely on statements in the PSR. They bear sufficient indicia of reliability, at least absent a defense claim or evidence showing that the statements are not reliable. On this record, as we outlined in our brief, we think the district court had an ample basis to impose the premises enhancement. Similarly, with the importation enhancement, the PSR makes clear that Karen Maxwell obtained her methamphetamine primarily obtained her methamphetamine from a source who obtained it from Mexico. And the PSR outlines that she was a supplier of methamphetamine for Mr. Jewell. The PSR also says, with respect to a timing issue that my friend on the other side raised, that during the course of the charged conspiracy, Mr. Jewell and two others bought methamphetamine from Ms. Maxwell at least three times. I don't think there's any dispute in this case that the evidence outlining the contours of the conspiracy in this case and the drug transactions relate to the time frame of the conspiracy. That was never disputed below. I didn't understand Mr. Jewell to dispute it in his opening brief on appeal. I would also note for the court that on page 35 of the record on appeal is the factual resume accompanying the guilty plea, where Mr. Jewell acknowledges that he and Karen Maxwell, among others, were co-conspirators in the charged offense to which Mr. Jewell pleaded guilty. So I think that's those facts in the PSR, coupled with the deferential standards of review that this court applies to the district court's factual findings, are more than enough for this court to affirm the enhancements. Again, though, I will remind the court that the issue is sort of irrelevant in this case, given the harmlessness point. A couple other points I want to make for the court. One is, in his reply brief, Mr. Jewell, I think, was making a claim that the district court procedurally erred by treating the guidelines as mandatory. I think Mr. Jewell today, or counsel on the other side today, seemed to make that point. That point was not raised in his opening brief, and so is therefore waived. It's also belied by the record at pages 169 and page 171. The district court twice referred to the, quote, advisory sentencing guidelines. I don't think there's any dispute in this case that the district court well understood that it had the authority to impose a non-guidelines sentence in this case. Just a brief word on the section 3553A factors. The law in this circuit is, I think, quite clear that, especially with regard to within guideline sentences, that the explanation requirement is satisfied as long as this court is comfortable that the district court considered the relevant factors and imposed a sentence on the basis of permissible considerations. In this case, as we outline in our brief, Mr. Jewell submitted his motion for a downward variance. The district court referenced that motion, and at page 163 gave counsel the floor to articulate whatever reasons counsel thought were relevant for a below guideline sentence, whether those were reasons advanced in the downward variance motion or otherwise. After counsel made his presentation, the district court thanked counsel, expressed appreciation for counsel's passionate arguments on behalf of Mr. Jewell. I think fairly read, that is a statement by the district court that the district court heard and understood counsel's arguments. Then the district court later at pages 171 and 172 of the record on appeal says that in the court's view, an upwards variance sentence might well be warranted in this case, given Mr. Jewell's extensive criminal history. And yet the district court did not impose an upwards variance sentence, but imposed a within guideline sentence. In our view, the fairest reading of the record is that the reason the district court did not impose the upwards variance sentence that the district court otherwise thought would have been warranted is because of the district court's consideration of the very factors that Mr. Jewell maintains that the district court ignored. I think that is responsive to most of the points that counsel on the other side made. I'm happy to answer any questions of the court on any issues raised by counsel or in the briefs. If the court has no further questions, we would ask the court to affirm the judgment of conviction.
Thank you, Mr. Goldman.
Thank you.
Mongaras, you have 5 minutes on the vote.
Yes, Your Honor. In some response to the importation enhancement, I don't necessarily, well, one, just because something is included in the PSRs does not mean there's some indicia of reliability. As this court has said, I think in Zuniga and Elwood, bald conclusionary statements do not acquire the patina of reliability by mere inclusion in the PSR. And that's what we have here, plain and simple. I don't think it's really disputed that the statements provided by the PSR and even the government are conclusionary or unfounded hearsay, uncorroborated hearsay, however you want to say it. It's not necessarily disputed. And the error here is not harmless. I understand the government's position that the court says, well, I think there's a reason for an upward departure. He did not upward depart. He kept him within the guidelines. And so even as the government points out, in the context of the sentencing and of what the actual sentence was given, I don't believe the court, I don't know how without explanation, I don't know how the court or this court can say he believed he could go above or below the guidelines. I understand.
Well, in this instance, so counsel, just because it's a 3553A sentence doesn't mean that it can't be within the calculated guideline. Back to my original question, if you took the 4 points away and recalculated the guidelines, the 275 months is still applicable under 3553A. However, if we sustain that, it simply happens to be a 3553A sentence that comports with the guideline calculation given the 2 plus 2 point enhancements that were applied. And I guess that's what I'm struggling with, that all things considered, you've still got a 275-month reasonable sentence imposed by the judge.
Which, and I understand the court. Obviously, we believe that is unreasonable based upon our 35. In essence, I from what I understand, the court asking and stating is that the 275-month sentence, if given or if I guess the objections were sustained, the court would be allowed under 3553A to upward depart. If that were the case, then obviously there would have to be some explanation on why he upward departed. And here we don't have, I could upward depart based upon criminal history, but he doesn't, this court doesn't say, however, because of the other factors, I'm not, or I take into consideration those other factors. None of that is present here. And I understand, and so while Judge, you are correct, Your Honor, you're correct in saying he could, the 275-month sentence could still happen. He would have to give some explanation, and none was given here. And I understand the court, and while the sentences within the guidelines require little explanation, more is required if the parties present legitimate reasons to depart from the guidelines. And that's from Santiago, from this court. And that goes back to Rita. And so while there is little explanation, there has to be something. And here, taken into context with what's in the record, even if the government says that I've waived an argument that I believe that the judge believed sentences were, that the guidelines are mandatory, it's in the record. This court can take into account the context of what happened at sentencing with regards to the objections that I made and with regards to 3553 arguments I made, and with little explanation given. So with that, if the court has any questions.
Thank you, counsel. Your arguments will be taken under advisement.